So hello, everybody. Welcome to class today. My name is Carrie Sotner. I'm the Chief Learning Officer here at the National Constitution Center. I'm literally here at the National Constitution Center. And today we're going to talk all about canonical or landmark Supreme Court cases. And to do that, we are with our top scholar, Tom Donnelly from the National Constitution Center. Tom, how excited are you about this topic?
I'm very excited. Happy New Year, everyone.
Yes, Happy New Year. We were talking about all these amazing cases that we're going to go through today. And, we're going to go through what makes them a landmark case. What's the significance of landmark cases and why do we study them? And then some of the big themes that we're going to look at today. So Tom, real quick questions for you before we get into this. What type of landmark cases are your favorite to look at? I bet I can guess. I totally already have a guess of what it is. But what are your favorite types? And then you're working on this big Founders Documents project, and you've been going through a million cases. And we talked about this earlier before class started, but I thought you could share with the students. We picked 8 cases today, 9 cases today, but how many would you put on your landmark list if you had all the time in the world? So we'll start off with that fun question, and then we'll dive into these. Not that they're not fun.
Yeah, no problem. My favorite landmark cases, Curry, are Bill of Rights incorporation cases dealing with the 14th Amendment. So the expansion of the Bill of Rights against the states and turning it into really a charter of national freedom. I love that story, and I love those cases. More broadly, how many landmark cases are there? It's almost like no matter what the number you give, you could fill it up with enough cases. I think that 50 is a good number that forces you. It's a big enough number, but it forces you to make tough choices. You can get most of the cases you really want, I think, in a list of 50.
So everybody, by this summer, you'll know the 50 cases that Tom picked for this project because we're going to launch it. And you'll be able to see what are the 50 big cases that the National Constitution Center thinks everybody should know. And then we'll have top scholars talking about it. It's called the Founders Library Project, and we're really excited about it. So on the baby version of the Founders Library Project, we're going to talk just about a few big cases. So what are landmark cases, and then why do we study them? And then let's look at the themes that we have the groupings in today.
Sure. Landmark cases, there really are big cases. There's nothing fancier than that. They're cases of great historical significance. They often involve really interesting stories, but importantly, they also really shape the Constitution's meaning. And so they often touch on things that we really care about, like the rights that are enshrined in the Bill of Rights, the promise of equality we find in the 14th Amendment, the division of power between the different branches of the national government, and the division of power between the national government and the states. It's all of those big constitutional principles. And why do we study them, Curry? Well, in part, it's because it tells us how the judicial branch works. One way to think about it is it tells us a lot about the Supreme Court's role in our constitutional system, but they also teach us about how constitutional law has changed over time, and sort of how certain big debates exist throughout American history, but sometimes the balance of power within those debates shift. And then finally, so many of these cases, as we'll see today, Curry, they involve ordinary Americans. So they often also emphasize for all of us how much Supreme Court decisions affect all of us.
And I love that. I think, I knew that going into our class that we teach earlier in this day. But even after last class, you forget sometimes the court will never hear a case unless it's brought to them by we the people or by we the state. And it's really important for these cases to not forget the people behind the cases and the impact that these cases can have on our day-to-day life. So some of the cases we're going to look at today are grouped in this way. So it kind of helps us all study them and remember them when we put them in groupings. So you want to walk us through some of these big groupings, and then we'll start diving into the cases.
Absolutely. So, there are many ways to divide up these cases, but we've divided them into a couple of cases that are Supreme Court foundations. These are early cases that really tell us a lot about the role of the Supreme Court and also how we're going to interpret the Constitution. But then the other categories are really big constitutional issues, like the Constitution's promise of equality, the battle over the Bill of Rights, battles over presidential power, and really battles between the branches of government altogether. And then finally, if we get there, the Constitution in the schools.
I love that caveat. If we get there, we always like to keep people on a cliffhanger. So let's look at the cases that we're going to try to get through today. And we're going to start with those first two that are bolded in red. So these are the cases, and we want to always make sure that you guys know that these PowerPoints and everything we do are all on our website in the module on landmark cases. You can dive into it, and you can also see that we have 69 slides on today's deck. We are not going to look at them all today, But if you want to have fun and go through all the amazing work that our team does to put visuals around these stories, go for it. So the first two cases we're going to look at set some foundations for the Supreme Court and, and to be honest, for Congress and how Congress works as well. So tell us the story of Marbury versus Madison, and then we'll jump to the second bank.
Absolutely. So Marbury v. Madison, it's 1803. It's very early in American history. The Chief Justice is Chief Justice John Marshall, in many ways, maybe the most famous Supreme Court justice of all. And the Supreme Court at this point in time, it's not that powerful. It doesn't do very much. And so part of what we're talking about with Supreme Court foundations are the foundations of the Supreme Court's power and its role within our system. And Marbury versus Madison is absolutely essential to that story. What's the big idea here in Marbury versus Madison? It's that it establishes the power of judicial review. So it sets a key precedent that the Supreme Court is going to have a key role in deciding whether a governmental action is constitutional or unconstitutional. So that's the power of judicial review, that power of the courts to look at a law, look at an action of the government and say, is it constitutional or unconstitutional? So that's the big idea. But what happened in Marbury? Well, Marbury involves a really interesting cast of characters. So you can see on the two ends of the row here, the two great frenemies in early American history, John Adams and Thomas Jefferson. So Marbury is growing out of the heated election of 1800. Thomas Jefferson wins. He declares a revolution. John Adams loses. He's angry. He's sad, much like John Adams is always angry and sad about something. But this case grows out of the series of positions that John Adams and his Federalist Party in Congress create right as they're going out of office. So this is the brief period of time between John Adams's election and Thomas Jefferson taking office. Some of the positions they create are what are called justices of the peace. We don't have to worry about what these are. These are just local officials, but these are offices that Adams and Congress create that allow Adams to fill it with Federalists, his fellow Federalists. So they're trying to both fill the courts and different offices of government with Federalists before Jefferson and the Democratic Republicans take over. So who are Marbury and Madison? Marbury is William Marbury, that second picture you see there. And he's from Maryland. He grew up on a tobacco plantation. He's a well-connected Federalist. The way to think about him is he's kind of like a big political donor of today, or sort of a political insider today. And he is given a position by John Adams as a justice of the peace. So he's given this position, one of these positions that are created as part of the midnight appointments at the end of the John Adams administration. And who's Madison? Yeah, it's that Madison, the really, really famous one, the father of the Constitution, James Madison. And so what happens here is John Adams, in the closing days of office, he's writing all of these commissions. These are literally sheets of paper with people's names on them, giving them different jobs in government. One of those jobs is William Marbury and his position as a justice of the peace. So John Adams writes out this commission on a sheet of paper, folds it up, puts it in an envelope, seals the seal of the United States on it. And so the commission has been signed and sealed, but the problem is that it's never delivered. So when Thomas Jefferson becomes president, it's sitting there on James Madison, the new Secretary of State's desk. And what Thomas Jefferson says is, Mr. Madison, my great friend, take that commission you see on your desk, put it in your desk drawer. We are not delivering these positions to the Federalists. It was illegitimate for them to create these positions. And so we are just going to say they are not going to take these offices. Their commissions will never be delivered. William Marbury says, this is not fair. I got this position. John Adams had the power to give it to me. The Senate confirmed me. This is my position. And so he says, deliver me my commission. What he does is he goes to the Supreme Court and he asks the Supreme Court to issue what's known as, the really fancy word for this is a writ of mandamus. All this means is he wants the Supreme Court to issue this writ that basically says, James Madison, deliver the commission to William Marbury. It's just a writ of mandamus is just something a court issues telling some official in government to do something. And ultimately, the Supreme Court has this power. Congress gave the Supreme Court this power under the Federal Judiciary Act. But John Marshall, the Marshall Court hears this case, Marbury versus Madison, and they say, no, Mr. Marbury, you lose. You lose. And what they say effectively is, we're going to exercise our power of judicial review to say Congress may have wanted to give us the power to issue this writ and give you this job, but that law that Congress passed was unconstitutional. And so we, the Supreme Court, do not have that power. And so effectively what Marshall says is, on the one hand, William Marbury, you absolutely have a right to this job. But on the other hand, we, the Supreme Court, do not have the power to give it to you. So this is a great move by Marshall. It allows him to jab at the Jefferson administration. Marshall himself is a Federalist, so Thomas Jefferson, his cousin, is one of his political enemies, and so he's able to say, you did the wrong thing here, but at the same time he says, we, the Supreme Court, we have no power to give this particular job to Mr. Marbury. At the same time, though, we are going to say we do have a really big power, and that's to take a look at laws of Congress and say whether they're constitutional or unconstitutional.
We jokingly say that the Supreme Court is like our parents, and they make these like giant moves and like lay out foundations for us to listen to. And I think this is like my favorite example of it, because he really does. He's like moving the shells around in like a shell game and saying, okay, I'm going to lay these things out. You're wrong. We still can't do it. And at the end of the day, we are able to do this big idea. So he's defining the role of the courts, and he's also defining the role of what Congress can and cannot do as well at the same time. So there's a lot of, this is why people think it's such an important case, because it is such an important case. You know, when we talk about these cases, sometimes the players in the case in the Supreme Court are so unbelievably huge and powerful. Sometimes they're just there at the right moment and right time. But when we talk about Justice John Marshall, Tom, what would you say about him being such an iconic anchor of the courts and what the role of the court is, and how his actions by who he was helped define the court?
Well, a few things. He was a great writer. He was a very good leader. And so he had a range of voices on the court, but he was often able to bring his colleagues together to speak with one voice. And he had a broader vision about, you know, the important, but in other ways, limited role the Supreme Court was going to play over time. So he had a vision for both the Constitution and for what the Supreme Court could be.
Awesome. And again, why we study these people and why we study these cases. Now, we don't leave him just yet. We go to the next court case and we dive back into kind of another band of characters playing together, looking at what's the role of Congress, what's the role of the states, and what's the role of the court being defined again, and what's the power of the court being defined again. So tell us about, and by the way, everybody, I was telling the kids in last class we had today, the Second Bank of the United States that you're looking at right there is right down the street from me. And it's a beautiful portrait gallery now. So if you're ever in Philadelphia, come visit us and then go check out the Second Bank. It's really cool. So back to you, Tom.
Absolutely. So McCulloch v. Maryland, it's issued in 1819. This is another John Marshall Court opinion. Who's McCulloch? It's James McCulloch. He's an official of the Bank of the United States, and Maryland is a state of Maryland. And so what the court's tackling here in McCulloch v. Maryland is one of the big issues in the early American history, and that's whether Congress has the power to establish a national bank. These debates went all the way back to the Washington administration. And so it's the first Congress and George Washington signing an important early bill that establishes a Bank of the United States. But those early debates really brought huge conflicts, huge constitutional debates between some of the biggest figures in early America. And so you have Alexander Hamilton on one side with a vision of broad national power under the Constitution, arguing that, of course, the Constitution grants Congress the power to establish a Bank of the United States. Why is a Bank of the United States important? For Hamilton, in part, it's about ensuring that the national government can play a key role in shaping national economic policy. And so Hamilton takes a broader view of the powers of the national government than some other figures at the founding, but he's countered by two other huge figures, Thomas Jefferson, who's the Secretary of State, and James Madison, who's in the US House of Representatives. And they say, Mr. Hamilton, come on, you know what we did with this Constitution. We created a national government that's strong, but also one of limited powers. And so we ask you, sir, look in your Constitution. Where does it say we can charter a national bank? Where is the charter bank clause of the Constitution? There is none. And so Congress does not have the power to charter a national bank. These debates, in the end, George Washington signs with Hamilton, signs this bill, establishes a national bank. But in McCulloch, what comes before the Supreme Court is the constitutionality of the national bank after it's been reestablished. This is the Second Bank of the United States, and the Marshall Court has to answer, in many ways, that debate we just heard between Hamilton and then Jefferson and Madison. So those sorts of arguments are before the Marshall Court. And what John Marshall says is, one, at the top line, it's that, yes, I agree with Alexander Hamilton. In the end, Congress has the power to establish a bank of the United States. And two, he says, what we have to do, what's important about this case in many ways is that Marshall tells us Marshall's view of how best to read the Constitution. And so he looks at the arguments of Jefferson, of Madison, of Maryland in this case, and he says, you are doing constitutional law wrong. You are looking at the Constitution the wrong way. The Constitution is meant to be a fairly short document that all Americans can read. That we the people, it's our document. It can't be so long that it's as big as this room that I'm in, or even bigger. He would say that would partake of the prolixity of a legal code. That's not what a constitution is. We must remember, as he said, that it is a constitution we are expounding. And as to this specific question, Marshall looks at the Constitution. He looks at Article 1, Section 8, and which defines the powers of Congress. And he says Congress has powers to do things like regulate interstate commerce, tax and spend, borrow money, raise armies. Furthermore, Congress is also given some flexibility in its power through the necessary and proper clause, able to effectively do other things that are necessary and proper to carrying out the powers listed in the Constitution. And so what Marshall says is, when we're looking at a question like, does Congress have the power to establish a national bank? We don't look for one specific clause that grants Congress this power. That's too specific. But we look at Congress's broader powers and see whether or not a bank fits within sort of that scheme of powers that are granted to Congress. It's what lawyers would call, Marshall saying that there are certain implied powers that Congress have, things that can be implied reading between the lines of the powers that Congress has. In the end, Curry, these debates aren't over. We debate, debates over the powers of the national government. People disagreed with Marshall at the time. People have disagreed with Marshall throughout American history. So it's not like Marshall gets the final word, but in many ways, this is establishing for this period of time, a fairly broad reading of Congress's power over the economy.
And that is such a great point, Tom. And so I just want to ring that bell one more time, because we hear sometimes students say, well, they made a decision and that's it. And I'm like, no, let's talk about dissent. Let's talk about all these other questions. And then also people saying, did they get it right? And then how are we going to interpret that today? So I think that's really, really important, and also really important kind of leading into the next grouping when we look at questions around the promise of equality in the Constitution. When we think about Dred Scott and Plessy v. Ferguson and Brown versus Board of Ed, it's not just the Constitution that we're looking for the promise of equality. We're saying, how does the Declaration of Independence and the Reconstruction Amendments affect the way we see equality in America? So this is where I thought your heart would lie in all of the ways that you love Supreme Court stories. So let's start with my favorite person to start with whenever we talk about the Scott decision is Harriet Scott. So let's talk with Harriet Scott. Give us the framing of this case and what she did to try to get equality and safety for her children.
Sure. So Harriet and Dred Scott, they're an enslaved couple. And Harriet Scott, she's a mother. So this case in many ways is all about Harriet Scott and her two daughters. Harriet Scott's grown up and had to live through the brutal institution of slavery, and she wants to do everything possible to make sure that her daughters don't have to live the same sort of life. And so she and Dred Scott bring their family's case before the courts. And what they argue is that we are enslaved people, and the slaveholder here brought us on to free soil and then back into an area in which slavery was legal. But that time on free soil, that makes us free. That's their argument. It's a personal freedom suit saying, once we are brought on free soil, we are now free in America. And so they're coming to court saying, courts, recognize our freedom. And so this case would weave its way through the courts. It would take 11 years until it finally got to the Supreme Court. In 1857, in an opinion by Chief Justice Roger Brooke Taney, the Supreme Court said, no, Harriet and Dred Scott, you were wrong. You lose this case. And what Chief Justice Taney does is he looks back at American history and he gives his own reading. And he reaches a conclusion that one, African Americans cannot be United States citizens. And two, they have, quote, no rights which the white man is bound to respect. Therefore, you have no right to be in court even bringing this claim. But like so many of these cases that are landmark cases, Chief Justice Taney here, his arguments don't go unanswered in his own time. So we can often look back at these cases and say, how could the Supreme Court decide this? Did anyone think otherwise? Or, was there debate? And here we see two powerful dissents in the Dred Scott case by Justice Benjamin Curtis and Justice John McLean. Justice Curtis actually resigns from the Supreme Court in protest, so outraged by the Dred Scott decision. And what they both Curtis and McLean argue are, Chief Justice Taney, what version of American history are you reading? They challenge him directly on his reading of American history. And they say, look back at the founding. Look back when the Constitution was adopted and ratified. African Americans were citizens in certain states. They could even vote. So what are you talking about, Chief Justice Taney? You are wrong. But furthermore, it's not just inside the court, but outside the court. If you look at Abraham Lincoln prior to being president, his Republican Party, what is one of their key arguments? Their key arguments is, Supreme Court, you got it wrong. Chief Justice Taney, you got it wrong. Dred Scott is wrong the day it's decided. And as soon as we take office, we are going to lead a constitutional movement that's going to make sure that either through regular laws passed by Congress or by amending the Constitution, we are going to speak back and say, Chief Justice Taney, you're wrong. African Americans can be United States citizens, and they absolutely have rights that everyone is bound to respect.
And again, the point of dissent, the point of, okay, you got it wrong, you are not right. I love that they call him on his history too. They're like, where are you looking for this history? Because we can't find the story of our country that you're reading right now. But the idea of changing the Constitution, okay, the Supreme Court stated this, they put this in the Constitution, how can we change it? Let's amend it. And that leads us so perfectly to ending slavery with the 13th Amendment, but the 14th Amendment. How connected is the 14th Amendment to the Dred Scott case in word for word?
The 14th Amendment, so the 14th Amendment does a lot of different things, but part of what it's doing, the first sentence of the 14th Amendment is a direct rejection of Dred Scott. It says that if you're born on United States soil, you're a United States citizen. Doesn't matter if you're white, black, just any ethnicity, race, whatever. If you're born here, you're an American. So Chief Justice Taney, you got it wrong. Furthermore, through writing key protections of freedom and equality into the Constitution, the 14th Amendment says everyone here has rights that everyone else is bound to respect, and that we commit to equal protection under the law.
And it's awesome. So I always, when I read that first sentence, naturalized citizen, when I read that first sentence of the 14th Amendment, I always, Harriet Scott's face pops into my head. So this is who's calling and saying, this is my right. This is my destiny from being born and living in this country. Now, we look at the court cases and we look at these great movements forward at times and these awful movements like the Scott case. And then we have, it's not just a simple line. There's a lot of zigzags back and forth and a lot of big steps backwards. So we have this great movement with the 14th Amendment that puts the Declaration of Independence, puts equality into the Constitution. And then we have Plessy versus Ferguson. So can you talk a little bit about Homer Plessy and this court case and what he fought for?
Sure. So Homer Plessy, he's an African-American. He's from Louisiana. He works with a group called the Committee of Citizens, which is largely a group of upper-class African-Americans in New Orleans. And Louisiana is this interesting state during this period because it was one of the parts of Reconstruction. So this period after the Civil War, where we had a massive experiment in multiracial democracy, Louisiana is one of the places that for a good amount of time actually got it right. And so we saw African-American governors, state legislatures, sheriffs, justices of the peace, going back to William Marbury. But so we see a burgeoning, we see a lot of a push for racial equality in Louisiana. But by the end of the 1800s, we see the backlash. And we see the rise once again of white supremacy in Louisiana. We see the imposition of Jim Crow segregation in Louisiana and throughout the South. And Plessy v. Ferguson is a lot about whether or not the Supreme Court is going to step in and check these laws that discriminate against African Americans, that force African Americans and white Americans to board different railway cars and onward and so forth. And so Plessy v. Ferguson, Homer Plessy, is a test case that's brought to challenge a Louisiana law that it's Separate Car Act, which required African Americans and white Americans to sit in separate cars. And what Plessy and his colleagues argue is that what is a clearer violation of the 14th Amendment's Equal Protection Clause? Of course, this is discriminating against African Americans and branding us as second-class citizens. But extraordinarily, in a 7-1 decision, Homer Plessy lost. The Supreme Court said, no, Louisiana wins. This Jim Crow law of segregation is constitutional. It's consistent with the 14th Amendment. Separate but equal is constitutional. So if you have separate facilities for white Americans and African Americans and they're equal, that's constitutional. What the Supreme Court effectively says is the state governments have broad powers to promote the health, safety, and welfare and morality of their citizens, and that a law like this separate car act is consistent with that power. And the opinions by Justice Henry Billings Brown, and he ends it also by saying, Mr. Plessy and your colleagues, your African American colleagues, if in the end you really think this is creating, some sort of, it discriminates against you or makes you feel like a second-class citizen, that's on you. If you look at this law, it doesn't say anything about racial discrimination. It's just providing separate facilities for African Americans and white Americans. And so that's what the majority of the Supreme Court said. 7 of the justices say, but there is a one. There is a lone dissenter, and he's Justice John Marshall Harlan. And so in many ways, it's a reminder, again, as we say so many times, read all of the opinions and cases so you could see all of the arguments. And here, what we see is that Justice Harlan's opinion in many ways becomes the famous one, the one that we still read so much today. And what Harlan says is exactly what we're thinking right now, which is, Justice Brown, what in the world are you talking about? In what world are you living in where forcing Louisianans, whether by race, separating them by race, saying white Louisianans go here, African Americans, you go here. How is that not violating equal protection of the law? How is that not branding African American Louisianans as second-class citizens? And so in the end, what Harlan famously says is that in the eye of the law, there is in this country no superior dominant ruling class. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. One of the most famous lines in all of Supreme Court history. And he also predicts that Plessy v. Ferguson would end up being just as infamous, just as hated, just as rejected as Dred Scott.
And I think I love bringing up these stories too, because so often people look at history and said, what were they thinking? Did they not know? And you can see it in these stories. Like, oh no, they knew. And this is what they said about it. And there was dissent. And then, I think about this. It took so many people, so many fights and so many battles to end separate but equal. But I always think about it, and we put that little third grader right in front, fighting the battle that all of us adults should have fixed before she got there, Linda Brown. So tell us the story of Linda Brown and tearing down separate but equal, beginning to at least.
Yeah, so this is Brown versus Board of Education, 1954. It didn't come out of nowhere. Like you said, Curry, part of this is decades upon decades of fighting by the civil rights movement, also by great lawyers within the civil rights movement, like the NAACP and Thurgood Marshall. But in many ways, this is all about Linda Brown. And, she's a third grader. Like, you look at the picture, it's an amazing picture. She's a third grader. She actually go on to become an educator and a civil rights activist herself. But here's her in third grade. And this case boils down to just her and her parents wanting her to go to her local school in Topeka, Kansas, the Sumner School. And the school officials said no. Why did they say no? Because of her race. It was an all-white school. She was African American. She couldn't go to the school. This is, again, classic Jim Crow segregation, much like we saw in Plessy v. Ferguson with railway cars. Here, we're seeing it in the schools. And what Linda Brown and her parents say is no. This violates the Constitution. Plessy was wrong the day it was decided, and school segregation, separating white students from African American students, violates the 14th Amendment's Equal Protection Clause. And in an amazing reversal, in Brown versus the Board of Education, whereas Plessy v. Ferguson was 7-1 against Homer Plessy, Brown versus Board of Education is unanimous in favor of Linda Brown in an opinion by Chief Justice Earl Warren. And he says, Linda Brown, parents all across America, in the end, you're right. Plessy was wrong the day it was decided, so they overturned Plessy v. Ferguson. They say separate but equal has no place in public education, and they say that school segregation violates the 14th Amendment's Equal Protection Clause. And so effectively what they say is, even if you had separate facilities, separate schools for African Americans and white children, and they were equal, and they never were, but suppose they were, even that alone, the separation itself, brands African American children with such a feeling of inferiority. It relegates them to second-class citizenship. And of course that violates the Constitution.
Awesome. Great story. Thank you so much. Now we are cruising through. We've got a couple minutes left. We're going to do it, Tom. Let's real quickly, West Virginia versus Barnett, because it's one of my favorites too. And then we'll go to Korematsu. And then we have like 2 questions. So we'll do that.
Okay, so West Virginia versus Barnett, it's World War II. So it's 1943, and West Virginia has put in place a policy in its schools that all students have to salute the flag. And so who is the Barnett in this case? Well, it's two children, Marie and Gaithy Barnett. They're 8 years old and 11 years old, and they're Jehovah's Witnesses. And so a core tenet of their faith is that that basically there is no law above God's law. And so as a result of their faith, they can't salute the flag or pledge allegiance in the way other Americans, and it violates the tenets of their religion. A couple of years in 1940, so a few years earlier, in a case called Gobitis, the Supreme Court, in a lopsided 8-1 decision, said schools can do things like this. And so you could require Jehovah's Witnesses to salute the flag, and if they didn't, you can punish them. And so in this case, what West Virginia does is West Virginia expels the Barnett children for their act of religious courage and religious dissent. And the Supreme Court, in an amazing reversal, only 3 years after Gobitis, the Supreme Court ends up saying in the case, no, we got it wrong in Gobitis, an opinion by Justice Robert Jackson. And what Justice Robert Jackson says, this ends up being a landmark case, not just because it's an amazing and powerful story of the courage of a couple of children and their right to conscience, religious freedom, even speech, all of those great rights that we see enshrined in the First Amendment, but it also tells us a lot about what role the Supreme Court is going to play in protecting rights. And so this is a classic case of the Supreme Court stepping in, striking down something that public officials have done in the interest of a religious minority, often in this case, an unpopular religious minority, and saying and explaining why we have a Bill of Rights. A Bill of Rights is specifically there to check public officials, even when the public officials are doing things that may be consistent with what the majority wants. And so there's a couple of amazing quotes I'm going to do before we do Korematsu, but two most famous quotes in the Supreme Court canon. One is from Justice Jackson here in Barnett. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, to establish them as legal principles to be applied by the courts. And then finally, this is just an amazing quote about the freedom of conscience. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act faith therein. Robert Jackson sure could write.
I have so much trouble with this quote because I start to highlight it and then I wind up highlighting the entire thing. You're right, it is an amazing quote. It's an amazing writing, and it is a powerful push from groups of children. I'm so glad you brought up the Gobitis case. We were talking earlier with Scott Bomboy, our editor-in-chief. He said so many of these cases are clusters. They're not isolated incidents. And the Gobitis children fought to have their freedom of religion and therefore not raise the flag. And these children did again. So it is really unbelievably moving. And that Robert Jackson's words are just something that I want on a t-shirt to wear. Any fixed star in a constitutional constellation is unbelievable. So really powerful. And as we kind of go through these stories, we look again at the power of people fighting against the odds and sometimes not winning and still picking up the fight and saying, we're going to do it for the next generation, for the next child, for the next family. And that brings us to Fred Korematsu.
Yeah, so this is 1 year later, Korematsu versus United States, 1944, still the World War II context. What's happened? Well, FDR issues an executive order creating internment camps for Japanese Americans. So taking them from their homes and relocating them to these camps right in the middle of World War II. The argument is we're at war with Japan and we need to keep America safe. And so in many ways, both FDR and the Supreme Court itself, they're acting in the fog of war, concerned about the national security of the United States. Who's Fred Korematsu? Well, you see a great picture of him here. He's a 23-year-old Japanese American, and he refused to go. He said, look, I was born in California to Japanese immigrant parents. I'm a Californian. I'm an American citizen. You can't take me from my home and force me to go somewhere else if you don't have a good reason. What are you doing? Of course, this violates the Constitution. He argues it violates the Fifth Amendment's due process clause. And in many ways, we may look back at this case today and say, of course, Fred Korematsu should win. What is clearer under the Constitution than that you can't treat someone differently just because of their race? That's just like a classic, of course that's going to violate the Constitution. But in a 6-3 decision, the Supreme Court sided with FDR, sided with the national government, effectively saying, look, we're at war. The national government has broad power in the end to win a war to protect the national security of the United States. And here we're going to defer to what the national government did. There was no racial animus here. They didn't just, take this out on Fred Korematsu because of his race. It's because we're at war with Japan and we have to keep America safe. But again, in a series of 3 really powerful dissents, this is a 6-3 decision. And so what we end up seeing is, one, Justice Brett Murphy in his dissent describes what the court does here as entering, quote, into the ugly abyss of racism. We see Justin Owen Roberts looking back at the court in dissent and saying, majority, what you're doing here, it sounds a lot like what those authoritarian regimes that we're fighting in World War II do. Why are we doing this in the United States of America? And then finally, Justice Robert Jackson, again here, this time in dissent, using his powerful pen to say, look, I used to be the Attorney General of the United States. I understand how important it is to the national government to have broad authority to protect the national security of the American people. I would generally defer to what the national government wants to do, but here, we cannot say yes to this policy that's based on raw racial discrimination. What that's going to do is it's going to leave a, quote, loaded pistol right there for future presidents to take up in times of war and effectively undermine our core constitutional principles.
And the Korematsu himself, Fred Korematsu, I was reading this not too long ago. He wasn't just, he's fighting against this and he's standing up against this, but it's also his family and his peers that are all telling him not to do it either. Don't do it, don't do it. And he says, I am coming to fight for my country, to show my loyalty. You cannot put me in a camp, because he winds up fighting in the war. All this unbelievable story, this unbelievable person. And when you look at the whole story, he's fighting against everything. He's fighting against his own family, his own community, telling him that don't do it, don't fight. This isn't what you should be doing. He's fighting against the government, and he's fighting a war, all under the idea for the freedoms of our country and what we believe in. So this is an amazing story. And he continued to fight for other people as a civil rights leader for years and years. And then Tom, do you want to wrap up the story with how he was finally pardoned?
Well, in the end, so what happens? Congress ends up studying this and grants reparations to Japanese Americans for internment. Fred Korematsu himself in the 1980s gets his conviction thrown out. He ends up getting awarded the Presidential Medal of Freedom. And the Supreme Court itself, finally, just a couple of years ago, said what we have long thought about Korematsu, which is that Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution.
And Emily just said it, I think the best quote of the day. Thank you, Fred. And you're right. Thank you, Fred. We appreciate you so much. One comment that came in from the chat, and you guys were awesome today, was just 2 hours ago in Louisiana, the Louisiana governor pardoned Homer Plessy. So
really? Interesting. Yeah. I had no idea.
That he still had to be pardoned bothers me, but on the other hand,
no, the whole
it's a mixed feeling on that one. And then we realized also, and we're wrapping up on this, and we typically talk about Tinker as well, but we're totally running out of time. When I think about Tinker, though, I always think of the picture of Mary Beth and John Tinker at the Supreme Court and their mother sitting right beside them. And we were noticing that so many of these stories have a strong mom fighting in the background to make sure that their children get the rights that they deserve and need. So we might have a new theme for Mother's Day, the moms of the Constitution, just so we're clear, Tom.
I like it.
Awesome. Tom, thank you so much. That was awesome. Students, thank you so awesome for all the questions, but also all the great shares in the chat. You guys were rock stars today. With that, I have one question for you, Tom, but I am going to, because I have to dig it up, I'm going to stop the recording